Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a passage of 800 words from Progressive magazine at the speed of 100 words per minute. So get ready for the dictation. 3, 2, 1 and go. Sir, the 4 specific things where I would like to draw the attention of the minister are: it has been provided in this bill that private limited companies who accept fixed deposits will be deemed to be public companies. Now, I see an amendment has come that this will not apply to companies getting deposits from relatives. But I venture to say that there are small family companies which can raise deposits from their own friends and associates. Why should they become public companies? They are not getting money from the public in the wider sense. If they are getting loans, they are small loans from commercial banks against securities. But bringing or by roping in all these companies, really what we are doing is that we are not applying the law to these companies but allowing law to become ineffective in the case of big companies, and this is precisely what is happening. For instance, in Mumbai or Calcutta, there are big corporations, companies which deserve to be closely monitored whether they are following the Companies Act or not. This cannot be done howsoever great our desire may be with a limited number of staff, and every year we probably can go on increasing the personnel in the company law department. But the administration of the act cannot be effective unless we do an ABC analysis and see that only those companies where public money is really involved are closely monitored, and there I say I am totally against this whole concept where we go on providing penalties for infringement. Penalty should act as a deterrent. How far are we able to deter the large companies from violating the law? Here I see a very strange amendment that in case government does not approve the managing director's appointment, the managing director will be fined rupees 500 per day for the number of days that he refuses to vacate the office. I do not understand this logic. The law should be that government has not approved the managing director's appointment and the managing director should therefore have vacated the office from the moment government has disapproved of it. But to provide a penalty of a few hundred rupees in the event of his continuing in office for the period when government had disapproved the appointment is very strange. The whole Companies Act should be looked at afresh. There should be a select committee, or the honorable minister can on his own bring a motion for a joint committee of both houses. Nothing will be lost if this bill is not passed immediately. The bill should be made thorough. Madam, I will be very brief and I shall not repeat some of the things that have already been stated. I do support the motion moved by the honorable friend. As I understand it, the Attorney General, when he gave his evidence or advice to the Joint Parliamentary Committee, based his theme on 3 essential points. One is that you cannot prove the negative, that the non-existence of middlemen or agent or whatever, despite the fact of payment of rupees 64 crores as a condition precedent to the contract which he had not actually seen. Therefore, the condition precedent to a contract which he had not examined and which the JPC also had not examined was sufficient ground to say that you can't ask to prove the negative. And thirdly, the condition precedent can also be oral. These were largely the three essential points which raise questions which I believe only the Attorney General can answer, because the legal experts and the Treasury benches would suppress their expertise and would rather come out with partisan aspects of that which is unsustainable. The Attorney General spoke of the Evidence Act. I hold the Evidence Act is essentially a procedural act, and a fact-finding committee such as our Joint Parliamentary Committee was not bound to follow the Evidence Act. There are also exceptions to the Evidence Act, like the principle of the primary burden of proving a fact lying with the party that asserts the existence of a thing. And the best example is a child born out of wedlock that is assumed to be the child of that couple, and whoever says that this child is not my child or is not born out of wedlock has to prove it to be so. Here, the Evidence Act is asking you to prove the negative. The responsibility of proving the negative lies on whoever makes the assertion. Therefore, the Attorney General is wrong. Therefore, it is necessary that the Attorney General be called here. Finally, I believe there are other constitutional requirements which make it necessary. Here is Article 299 of the Constitution of India, because this is related to the Attorney General giving advice that the condition precedent could be oral. It can be oral in respect of non-government contracts only. Finally, under Section 92, in fact, the Evidence Act excludes oral evidence. Stop.